Hello viewers, welcome to the YouTube channel Lex Consilium Foundation, and I'm Major General Neelendra Kumar. In the playlist Inse Miliye, we are taking up something quite significant and perhaps a little uncommon. Judiciary, as you are aware, is one of the most important, in fact, one of the salient features of under our constitution for the democracy, for upholding rule of law. And the Constitution of India has clear, distinct provisions relating to judiciary. Right at the outset, the preamble secures to the citizens justice, political, social, and economic, and this justice shall be administered according to the scheme of the Constitution by judiciary, which has a Supreme Court at the apex, and each of the states have high courts. They are independent, and we have the three chartered high courts, which is still function. They are quite elegant and grand scheme of traditions. And I would remind you, or I would take you to the oath that a judge, the higher judiciary, is required to take under the Constitution, indicated in the third schedule, where he says that to the best of his ability, knowledge, and judgment, he would undertake, discharge his function. Now, proceeding from there, where the selection criteria and eligibility of judges in the with the constitutional courts is enshrined, indicated in the Constitution, and of the district judiciary, it is there in also not in the Constitution, but clearly made up. Now, a point that we take up for discussion today is whether a system of training of judges is adequate, wholesome, foolproof, and to accord proper light on this, we have the most competent, distinguished resource person here who would be speaking, Justice Abhay Oak. Justice Abhay Oak had been the Chief Justice of Karnataka and Bombay High Courts. He sat in the Supreme Court from August 21 to May 25, and he is respected amongst one of the most competent, fearless, and erudite judge to have adorned a seat in the Supreme Court. Now, with this background, Justice Oak, may I request you to throw some light, and for the benefit of the viewers, I would say that as of now, each of the state has a state judicial academy, and there is a national judicial academy at Bhopal, and there is a system that in almost all the state judiciaries, the candidates, after their selection by the due process, they go there for a specified period and they are trained. However, there is no mandatory structured training for the persons of eminence. I would say that all are of eminence who are selected and they take oath to sit in the high courts. All yours, sir.
Thank you, sir. We'll divide judiciary into three categories. The first category is at entry point, where civil judges come judicial magistrates first class are appointed. As far as this category is concerned, there is an entry point. There is a judgment of the Supreme Court which says that there is mandatory 1 year's training for civil judges come judicial magistrates first class. That's the part of the judgment of the Supreme Court. Now, training is imparted in judicial academy. It's a very rigorous training. Of course, every state follows a different pattern. In some states, there is 3 months training. Then these newly appointed judges go back. They sit on the dais with the senior judges, then again come back. So there's a very rigorous training on all aspects for a period of 1 year. Now that training includes training about the conduct inside and outside the court. Of course, training about provisions of law. There are mock trials conducted. Mock judgments are directed to be written. So it's a very, very exhaustive training. And these judges, after they go back after 1 year and start working, they have to come back for refresher training. This is the one point of entry in the judiciary. The second point is where senior civil judges are promoted as district judges. Invariably in all states, after promotion, there is a training given before the judges start discharging their duties as district judges come session judges. The third category is where there is direct appointment from the members of the bar as district judges. Now, their candidate has invariably experience of 7 to 10 years in practice, but still thereafter, almost in all states, is subjected to rigorous training for 6 months. So, training as far as our trial and district judiciary is concerned, it is mandatory, and I have seen many judicial academies, many state judicial academies. I have gone there as resource persons. By and large, all judicial academies have good infrastructure, and some of the judicial academies are really good. They stand out. This is one part. The second part is about High Court judges. You know that certain percentage of the post of High Court judges are reserved for district judges cadre. So naturally, somebody who has taken training, somebody who has worked as a district judge, say for at least 15 years or even more. In fact, my experience is that those who come through this cadre, most of them have put in more than 20 years. So they are very seasoned judges, and they start performing a different role. Even if the role is different, the court is different, the basic work as judge remains the same. So I don't think they require any specific training. The other categories of lawyers, I'll go back into the history. In my time, normally successful lawyers who have put in say 20, 25 years were invited by the chief justices to become judges. Today the position is the same. And obviously, when somebody has practiced for 20, 25 years in High Court, he has a substantial income, and then it is only because it is considered as an honor or call of duty that some of the lawyers accept it, because there is huge disparity between income of a judge and income of a successful lawyer in the High Court. Now, if you practice for 20, 25 years in High Court, then you know how to read the laws, you know how to interpret the laws, because as High Court lawyer, you handle different categories of cases. So your brain is trained to interpret the law. Then what happens is that if you are appointed as a judge from the bar, practically in every High Court, and especially bigger High Court like Bombay, you have to sit as a junior judge on the division bench. Then you get opportunity to sit with very distinguished judges. And that is some sort of, there you get, I won't say training, but there you start learning the art of judgeship, in the sense that somebody who has put in 20 years of practice, he knows the law, he knows how to interpret the law, he can analyze the law, he can analyze the facts, he can marshal the evidence, but few tricks he has to learn, namely how to handle the members of the bar, some techniques of case management, which he often gets to learn while sitting in the division bench. Giving my example, I was very lucky. I had occasion to sit for a long time with Justice C.K. Thakkar, one of the most accomplished judges of the Supreme Court. Yeah. Then I sat with Justice Ajit P. Shah. Though he did not reach Supreme Court, he is regarded as one of the best judges we had. Then I could sit with Justice Ranjana Desai, Justice Hemant Gokhale, who became judges of the Supreme Court. So as far as bar members are concerned, I don't think they require any formal training, because they are already equipped. In fact, they are sometimes we find that in terms of interpretation of law or interpretation of constitutional law, sometimes they are better equipped than the district judges who have spent in 20 years in judiciary. So I don't think any formal training is required for those who are elevated from the bar.
But I would like to point out that firstly, as far as the training at the State Judicial Academy is concerned, there is no doubt, as per the Supreme Court judgment, it is mandatory. But at the same time, all the states, this training is not uniform. It is not similar. So whatever is the syllabus, curricula, that is not uniform, number one. It is may differ, and it does differ. Secondly, the faculty to impart that training, to inject knowledge at the State Judicial Academy, that also is perhaps not fully trained, justified. Earlier, there used to be some faculty members chosen, like, say, for example, Madhav Menon went to the National Academy, and eminent professors were selected. I'm not saying that that is the only thing, but that system has not been followed, and right now it needs to be seen whether the faculty which is selected to undertake this job at the State Judicial Academy, that is up to the mark, and that is the best available. The third aspect is that the training being mandatory and successful completion of training. So I'm hinting at the assessment part of it, that the candidate who was found fit for induction, but whether on ground at the training academy he is so, that is not seen. Now, secondly, come to the aspect of those from the bar and selected to be the High Court judge. I'd like to just point out that it is said that advocacy and lawyering are two different things. And there are countless examples where people excelled in one, not in the other. And there, of course, there were few who excelled in both lawyering and advocacy. Judgment or judging is entirely a different cup of tea. While being on the other side, watching a judge does not make a person who has practiced for say 15 or 20 years, while the minimum is 10, doesn't make him qualified to undertake that job of a judge satisfactorily. Thirdly, there are aspects of writing of judgments, court management, etc. This also, a judge, a lawyer, advocate with 20 years, he may not discharge or live up to this aspect. And also it is to be borne in mind for these 20 years to have acquired a good practice. One has specialized, one has undertaken, one has become adept in promoting the cause of his client to attain success in the matter that he has been assigned by the client in the High Court. That impartiality, that fairness, that reason which is expected in a judge, does he just get it and acquires by sitting as a junior judge on the bench? I would request your comments on this.
See, please look at the position of a lawyer. He has such a vast experience of practicing for 20 years. See, it's not see, nobody can say even today, after working for 22 years in 3 different constitutional courts, I can't say that I know the law because there are thousands of enactments in our country. What is important is developing an approach which lawyer has. Lawyer has that approach. 20 years or 25 years he works, he handles different kinds of litigation, and obviously he can't handle all categories of litigations. I'll give an example. In fact, Chief Justice Shagla has written in the book, a lawyer is a civil lawyer. If he becomes a judge, for him, criminal law is a simple affair. And in fact, I can share from my experience that if you talk to the members of the bar, you will find that those who were civil lawyers regarded as more successful on the criminal side because they are more liberty oriented. Their approach is more liberal. That's a matter of fact. So and one more practical thing which I want to tell you. Firstly, I must tell you that somebody who has put in 20-25 years when he is called by Chief Justice to accept judgeship, today's scenario is that people are reluctant to accept judgeship. Chief Justices are required to persuade the lawyers to accept judgeship because of the work-life balance. Because if you become a judge, sometimes it's 14 hours a day, 15 hours a day, even in so-called vacations, at least 2 or 3 weeks you spend in dictating judgments. You have to do so much of administrative work. You have to write ACRs of the judges. You have to read hundreds of judgments of the trial and district judiciary. So even that is one factor, apart from low income, that work-life balance. These are the 2 factors which deter from many distinguished lawyers from accepting it. See, my time was different. When I became judge in 2003, at that time it was considered to be a great honor. So people are willing to accept it. But now the profession has become more lucrative now in the last 20-25 years. So as it is, seasoned lawyers show reluctance to accept judgeship. If they are told that they will have to undergo 1 year's training, then whosoever is willing, even they will not be willing. And in lighter vein, I am saying, but I am really telling you from my experience, I don't think if you are a seasoned lawyer, you require any kind of training. It's not at all necessary. Now, coming to the first part of the question, you are right in one thing, that though there is 1 year's training, there is no uniform pattern in judicial academies. There you are right. In some states, judges undergo training for 6 months at a state, then they go to the districts, sit on the dais with senior judges, then again come back. In some states, it is 3 months also. So there is need to bring uniformity. As far as resource persons are concerned, I'll tell you what is the structure of the judicial academies. 2 or 3 senior district judges are posted there, and directors, joint directors, nomenclature will differ. So they are full-time faculty members there. And almost in all high courts, retired high court judges, retired district judges, retired Supreme Court judges, they are regular faculty members. I mean, talking about Bombay, I can share with you that large number of retired high court judges go there as faculty member, retired Supreme Court judges go there. Same is the case with Karnataka. So I don't think major states, there is a problem about the faculty. Large number of good faculty members are available. But as you rightly say, what is required is a uniform pattern of training on which all high courts and perhaps Supreme Court will have to take initiative and work on that. And secondly, you may not have said it in so many words, but I feel that, say, after 5 years or 10 years, we must have a relook at the syllabus in the judicial academies. So Because now, for example, during last 10 years, there are more and more cases involving technology. So maybe some training in technology, cyber laws is required. So there you are absolutely right. Now, one more thing I want to tell you, after a judge is appointed either as a civil judge or direct district judge, he is on probation for 2 years. When his case for confirmation is considered by the High Court, there is appraisal by the Judicial Academy also. That is the regular faculty members who are stationed in Judicial Academy, they appraise. Their judgments are assessed by a committee of judges, and then the process of confirmation takes place. There are instances where if the judges feel that performance is not satisfactory, then High Court grants extensions, say of 1 year or 2 years, to enable the judge to improve and complete the probation. So therefore, there is assessment of the performance of the newly appointed trial and district court judges through judicial academies as well as by the High Court.
I would seek your comments also with regard to a few matters that have just emerged here. Firstly, having regard to the reluctance on the part of competent, good advocates to accept judgeship, well, that does not mean that in any way the standard should be lowered. Well, it's a case that the pay, perks, or whatever facilities, amenities are there, that should be looked into to make the job more attractive, acceptable. That's one part. The other thing is that if a system can be there at the State Judicial Academy that expects or that demands satisfactory performance as a judge for, say, a couple of years before a person is confirmed from the probationer status as a district judge. It's for consideration whether some sort of similarity should be brought in for the High Court judges also to watch them before sort of they continue in that task, because the task assigned to a judge is something very, very sacred, very important, and in that the personal competence of a person that comes to surface later after selection should not be an obstacle. The third thing, of course, you have brought out with regard to the need for periodic review or look at the syllabus. There should be clinical, periodic legal professional training. And fourthly, perhaps it is time that the higher judiciary, as a collective body or eminent persons from there, have a relook at the latest practices in the other jurisdictions. Just because the system has been continuing for decades doesn't mean that this is the only system, and it should sort of persuade us not to look at any other options. What would you say to that?
Last thing, you are right. We must look at the best practices elsewhere. But you know what is happening in High Court like Bombay? From my experience, I tell you that 2 years of sit in the division bench, then start sitting single. The filing and pendency is so huge. Single judges, I am giving an example of Bombay High Court, it may be two of other High Courts also. It is a routine practice that though the court hour end at 5 o'clock, judges continue to sit till 7 o'clock. So the work, the sheer pressure of work is such that, you don't have time to look at what is happening in other countries. I have experienced that. At 7 o'clock also, when you rise from the court, you find 50 people standing there. The expectation that will take up the matter. So the sheer pressure of work and the time which is required to complete your work, then it's very difficult for judges to find out what is happening in other countries. One more important factor which I forgot, why competent lawyers who are good practice in High Court do not accept the offer. That reason has arisen very recently during last 10 years. That is because of uncertainty. Now, what happens is, there's a very common pattern now that High Court Collegium recommends your name, though it is secret, but across the corridors, everybody knows that name of this person has been recommended. Then when the Supreme Court Collegium confirms that recommendation, accepts the recommendation, it is on the website of the Supreme Court. So everybody knows. Now, during last 10 years, we have seen that central government sometimes takes 9 months, 10 months, 11 months, or even more than 1 year. Please look at the position of the lawyer who gives consent. The moment Supreme Court Collegium resolution is on the website, his workflow stops, because which litigant will give him work? He knows that this man is going to become a judge. Litigant will feel, why should I pay his fees? Because he may walk out. But now the problem is, the names remain hanging with Union of India for 10 months, 11 months, 12 months. Place yourself in position of a young lawyer. Young in the sense he's 45, 47, 48. He has family to look after. And if his appointment gets delayed by 10 months, 11 months, 12 months, During that period, he had no income. So this is one more recently which has arisen during last 10 years. The advocates say that there is no certainty in the process. So why should I say yes? This is also very important part. And I must also tell you one more thing. In National Judicial Academy, there are courses conducted for newly appointed High Court judges. And when circular is sent to the High Court, Chief Justice are supposed to nominate newly appointed judges turn by turn. That training is at the weekends, where mostly retired Supreme Court judges, sitting Supreme Court judges, they are there for the training at weekends. That facility is also available. About appraisal of the work of the High Court judges, I must tell you something which sounds to me very odd. If you look at the law, constitution, somebody can be appointed as directly as a judge, and somebody can be appointed as additional judge. The judgment of the Supreme Court says that if there are no vacancies for the post of permanent judge, then a person is appointed an additional judge. Because if you see the website of the law ministry, you will find that each high court has say X number of post of permanent judges and Y number of posts as additional judges. Yeah. So additional judges are appointed only if there is no vacancy for permanent judges. But in practice, what happens is after a judge is appointed as additional judge of the High Court, then before Collegium recommends him for the post of permanent judge, the Chief Justice constitutes committee of 3 senior judges who are not members of the collegium but senior judges. Now that committee analyzes judgments of the additional judges of the High Court. There is a report submitted and then perhaps the collegium takes a call. So there is some method in existence as far as this is concerned. Personally, I feel that this is wrong. If you find a person fit to be appointed as an additional judge, how he can be subjected to scrutiny by his own colleagues? That's one point of view which I feel. But that system is there. That system is in place today. I will not take names of all great judges, whether they require training. Now, there are judges, some judges of the High Court who completed only 10 or 15 years in practice. They were taken as judges.
Quite right.
Were great judges.
And of late, there's also been a practice of some sort of appraisal of the performance of a judge, having regard to the quality of judgments, the number of judgments they have set, a number of cases where the judgments are in dissent, etc. So therefore, there is a need that the judges also, if I can say, they should be kept on their toes so that they put in their best. It is not that they end once a warrant is issued and oath has been taken. Well, they are beyond scrutiny. That feeling should not be able to permeate.
There's a flip side to it. Judges, there is a method, official method of keeping judges on their toes.
Yes.
That will directly affect independence of the judiciary.
Well, certainly some ways and means have to be devised in consultation with the judges, because there has to be a remedy. And of course, remedy should not become more stern than the cure. I agree with you, but there should be some method.
We must create a situation now will encourage successful lawyers to accept judgeship of the High Court.
Gee.
It's very necessary. And I have seen this transition because in my time, I'm talking about 2003, I became a judge.
Gee.
Practically every successful lawyer, barring few exceptions, used to say yes. There are of course some successful lawyers who felt that their temperament is not suited to judgeship.
Gee.
To require a different temperament. But now we must bring back such kind of a tradition which was existed say 25 years back, where every successful lawyer practicing High Court says yes. And for that, perhaps we need to improve the service conditions. We need to improve the work-life balance. And most importantly, we are able to bring about certainty in the process of appointments. And if appointments come within short time or within reasonable time, then still number of lawyers will say yes. In fact, I can tell you, keep aside improving the salary and perquisites. Let us keep aside that. Even today, if there is certainty that a good lawyer says yes and his name is through within 4 or 5 months, he gets warrant of appointment. Even if this situation we are able to bring about, I think large number of good lawyers will immediately accept the judgeship.
Certainly. And also, with regard to the training, I am reminded of what Justice Hidayatullah has written in his autobiography. His father was a judge, and when the younger Hidayatullah was appointed as a magistrate, and the first thing the father told him and stressed upon him was to write short judgments. And for that, he told him a trick. He says, after written down your judgment, read it once again, and the portion that impresses you most, delete it first. So therefore, the huge pendency which is there, perhaps one of the reasons is the long arguments which go on endlessly, and very long judgments which perhaps do not illuminate anybody. About that, we'll talk some other time.
Only
Thank
one
you.
thing I want to add. One thing
Yes.
I want to add. See, I talked about service conditions in terms of salary. But
Ji.
when I visit judicial academies, I deliver lectures in bar associations. I continue to visit all judicial academies even today.
Ji.
I always tell your lawyers or newly appointed judges from my own experience.
Ji.
I have been a lawyer for about more than 20, slightly more than 20 years,
Ji.
judge for about 22 years.
Yes.
I always tell them the work satisfaction you get as a judge can't be compared with work satisfaction you get as a lawyer.
Fantastic. Yes.
Right. Then you feel that you have done something for the nation.
Yes.
If you discharge your duties as a judge, enormous satisfaction you get.
Justice
For
having been imparted. Yes.
right. So that also is very important point, and that is so important that sometimes young lawyers will also feel that all right, we'll forget about income, but we'll join judiciary.
It has been very illuminating, and this sort of conversation will continue. Thank you.
So thank you.